Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legallistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support.
So today on the podcast, we have one of my favorite cases that I've recorded, the 2021 Ontario Court of Appeal decision in Wiseau Studio LLC and Harper. So just so everyone knows, this is the corporation that is made by the Tommy Wiseau, famous for his pop culture phenomenon, The Room. And the opponent in this case, Harper, is one of many in this who helped create a docuseries or a documentary film, rather, on The Room. And this film in particular was called Roomful of Spoons. And very briefly, the facts are Tommy Wiseau claimed that this company was misappropriating his likeness, copyright infringement, and all this other stuff. Roomful of Spoons, on the other hand, has just been trying to get this movie out for, I think, like 6 or 7 years. They just want to get this fun documentary out, and Tommy Wiseau will have nothing to do with it. And really what this case deals with, beyond the fun pop culture fight we have here, is security for a trial judgment, right? This is something that exists under the rules of civil procedure, but has never really been wrangled with by the courts. So I could get into the whole decision, but I won't, because it's good and it's worth the listen. And it's kind of funny to watch how the court just absolutely slaps money down and says, Wiseau Studios, if you guys want to play hardball, this is how.
Oh my goodness. This seems, look, we do a lot of really heavy, serious stuff here. A lot of the time, I think, this is our 10th or 12th one of the day, and we've already done 5 sexual assault cases. So it's nice to not, and to do something that's, still legally relevant because of, security for costs and vexatious litigants and stuff, but also is really fun. So it's a nice change of pace for us, I think. Lighten the mood a little for spring, I think.
Yeah. And it's fun to do something that not only references what I describe as quite the pop cultural phenomenon in The Room and Tommy Wiseau, but I think it'll actually be a good case for law students who are interested in civil procedure generally, because it actually kind of goes through, and this case demonstrates a great example of a vexatious litigant and somebody who security for judgment should be issued against, because I think the court even says, we've never really had to deal with this yet. This doesn't happen. This is not something we're used to. There are a few examples, but, sometimes it's cool that we get a case where it says, boom, these are the parameters. And when you get somebody who does something like this is when security for judgment will happen. Which, like I said, I'm a bit of a civil procedure nut now since I started articling. I love it. And it was fun for me to see this case come out as I was checking the ONCA cases one day. Because I was like, that can't be the same Wiseau.
Could there be more than one?
It's a French name. Yeah, it's a French name. Wiseau Studios, maybe there's another film company in Ontario. Not impossible by any means. But then, of course,
yeah,
you start to read in about 3 minutes and you go, this is going to get good.
It's that Tommy Wiseau. Oh, I see. Yeah, I know.
Yeah, exactly.
I self-admittedly have not seen The Room or the movie they made about The Room or the book. But my brother, my brother's done all of them and has informed me about all the hot goss about Tommy Wiseau. And he said the best part of the book is when the actors are worried that their checks won't cash for being in the movie, and they go to the bank, and the lady takes, the teller, very unprofessionally takes one look at the account number, and she's like, from that account? Oh yeah, there's tons of money in there. And they're just like, why? How? Who is this person? He's a character. It's a super fun decision. I'm actually really glad you recorded it, because this is a very nice change of pace for us, I think.
Yeah, it is. I'm happy I recorded it too. I sincerely hope all of the civil litigation geeks out there get to take a listen to it, even just to break up the usual monotony. Because, it's not too often we get rules of civil procedure decisions.
Yeah, no, never.
From courts of appeal.
Especially given...
Very infrequent.
Yeah, especially given sort of the current, the restrictions the pandemic is putting on the court system, and how, obviously, criminal matters are taking precedence to civil ones. So we're having a lot of civil law backlog lately. So, yeah.
Yes.
Super interesting.
Yeah, so not much else to say about this one other than listen to it, enjoy it. If you watched The Room, if you watched the docuseries on The Room, if you know anything about Roomful of Spoons, let us know on Twitter. Tell us about it. I think this is a great case for us to just, have a little bit of fun with, as opposed to some of the more serious stuff. So I hope you guys enjoy the listen. Between Wiseau Studio LLC and Tommy Wiseau, and Richard Harper, Fernando Ferrero McGrath, Martin Rasico, Rockhaven Pictures, Roomful of Spoons Incorporated, Parktown Studios Incorporated, and Richard Stewart Towns. Heard on January 7th, 2021 by video conference. Reasons for decision written by Justice Thorburn. Reasons for decision. Relief sought. This is a motion by the moving parties Richard Harper, Fernando Ferrero McGrath, Martin Rasico, DBA Rockhaven Pictures, Roomful of Spoons, Inc., Parktown Studios, Inc., and Richard Stewart Towns, together Roomful of Spoons, for the security of the trial judgment, costs of the judgment, and appeal, and, in the alternative, an order to lift the stay pending appeal. The security for amounts are as follows. Security for the trial judgment in the amount of $200,000 Canadian and Canadian currency is sufficient to purchase $575,488.36 at a bank in Ontario listed in Schedule 1 to the Bank Act at the close of business on the first day on which the bank quotes a Canadian dollar rate for purchase of the foreign currency before the day payment of the obligation is received. 2. Security for costs of the trial judgment in the amount of $481,521.80 Canadian, and 3. Security for costs of the appeal in the amount of $30,000. Roomful of Spoons claims that although security for judgment has not been awarded by an Ontario court, the unique circumstances of this case warrant security for judgment awarded and had been awarded by other courts in Canadian jurisdictions. Roomful of Spoons also notes that the British Columbia and Alberta courts have granted security for judgment in similar circumstances. Background evidence. In 2003, Wiseau Studio LLC and Tommy Wiseau, doing business as, quote, Wiseau Films, released a feature film called The Room. The Room and its creator, Tommy Wiseau, acquired cult-like status. Wiseau Studio and Tommy Wiseau are residents of California. Richard Harper, Fernando Ferrero McGrath, Martin Rasico, and Richard Stewart Towns are Ontario documentary filmmakers. In 2016, after years of work, they completed a documentary film called Roomful of Spoons about the cult phenomenon surrounding The Room and Mr. Wiseau, known as the documentary. Roomful of Spoons' only material asset is the documentary. Roomful of Spoons have not been able to exploit the documentary since Wiseau Films brought a claim against them in 2017. On June 14, 2017, Wiseau Films obtained an ex parte injunction restraining the release of the documentary, while, unbeknownst to the court, it was in negotiation with Roomful of Spoons about the documentary's release. On November 1, 2017, the injunction was dissolved as the motion judge held that Wiseau Films had failed to make full and frank disclosure and engaged in litigation misconduct. Roomful of Spoons was awarded substantial indemnity costs of $97,034.68. The cost awarded was not paid for 11 months and was paid only after the court advised that Wiseau Films' claim would be dismissed if the cost award was not satisfied. Thereafter, the case management judge found that Wiseau Films engaged in, quote, roadblocks to scheduling at almost every attendance, end quote, and other improper acts. These include A. The injunction was issued at a, quote, commercially critical time, end quote, when the parties were on the verge of finalizing a distribution deal which was prevented by the injunction such that the lawsuit had the effect of blocking the release of the documentary. B. Wiseau stated falsehoods about the defendants on social media and made misrepresentation to third parties about the legality of screening the documentary. C. Both sides agreed to file affidavits from their witnesses regarding their anticipated testimony in chief. Thereafter, Wiseau Films sought an order from the case management judge to direct the Crown to prosecute the defendants for perjury based on their affidavits, although he never identified what was allegedly false. The request was refused. D. Seeking to adjourn the trial on the eve of trial on the grounds that Wiseau Films no longer had counsel. The case management judge held that this was a, quote, situation entirely of their own making, and one about which he had warned Mr. Wiseau on many occasions, end quote. Since February 2019, the case management judge had dealt with 3 different motions from 3 sets of counsel for Wiseau Films asking to be removed from the record, and E, on the eve of the trial, sending the judge and opposing counsel a document entitled, quote, total withdraw, end quote, purporting to discontinue his claims. In the document, Wiseau Films attacked the Ontario justice system and stated that a new action would be brought in another jurisdiction for the same relief. The request was refused. Following an 8-day trial in January 2020, Wiseau Films' claim was dismissed and the judgment granted in favor of Roomful of Spoons on the counterclaim. The judgment was thorough and comprehensive. Roomful of Spoons was awarded $200,000 in punitive damages, and large part for litigation misconduct, $550,000 United States dollars in damages arising from the improper ex parte injunction, $25,488.36 in United States dollars in prejudgment interest, and $481,521.80 Canadian in costs. Thereafter, Wiseau Films' request to vary the judgment was dismissed, with costs to Roomful of Spoons in the amount of $20,000. In his reasons, the trial judge refused to allow evidence from witnesses that testified at trial and that could and should have been adduced at trial. He also noted that nothing presented on this motion suggests that my reasons for judgment were based on misleading evidence or that there was any other reason to reconsider my decision or reopen the trial. Rather, this motion raises the same concerns referred to by Justice Cohen prior to trial, and that the plaintiffs seek to delay justice for the defendants at every turn. Once again, Wiseau also complains of the Ontario justice system being unfair to him as, quote, an American citizen doing litigation in a foreign and unfamiliar jurisdiction, end quote. This claim, and other criticisms of the Ontario courts, was made by Wiseau in advance of trial and also at the outset of the trial. However, Wiseau chose to bring this action in Ontario, and no doubt was quite content with our system of justice when he obtained his ex parte injunction. I am not aware of any way in which he has been treated differently than if he were a resident of Ontario or a citizen of Canada. In my view, this motion has no merit and is yet another tactical attempt by Wiseau to delay and obstruct the release of Roomful of Spoons. Thereafter, Mr. Wiseau failed to attend examinations in aid of execution, or court orders compelling his attendance to provide information about his assets. Counsel for Wiseau Films advised that, as for the location of the assets which could be used to satisfy any judgment, the bulk of my client's assets may be located outside Ontario, namely in the United States of America. As you are aware, should you wish to proceed with an execution against any U.S.-based assets, the proper procedure for your side would be to convince a U.S. court of proper jurisdiction to endorse the judgments and orders issued by the Ontario courts. Mr. Wiseau refused to say whether a sizable real estate asset called the Pico property, which was the only known address for Mr. Wiseau, was still in his address, and said that it was, quote, laughable, end quote, to ask. No information has been provided about any Wiseau Film assets or their whereabouts, save for the bald assertion that Wiseau Films can satisfy any judgment award. Wiseau Films has now brought a notice of appeal of the trial judgment. Wiseau Films' counsel does not dispute that the amended notice of appeal, which grounds provide only that the court below erred in dismissing his various claims, is frivolous on its face. He suggested, however, that there was still time for further amendment to the appeal. Positions of the parties. Roomful of Spoons claims costs of the judgment and security for costs of the trial and appeal on the grounds that there is no evidence that Wiseau Films or any of its assets is in the jurisdiction or that Wiseau Films would agree to pay any order of this court. Roomful of Spoons also submits that Wiseau Films' improper behavior in making numerous tactical attempts to obstruct and delay these proceedings and its frivolous appeal justify the relief sought. Roomful of Spoons claims these actions are clear evidence that, having chosen to commence legal proceedings in Ontario, Wiseau Films does not intend to comply with an Ontario court order and that security for judgment and cost is therefore required. Wiseau Films disputes the motion for security for judgment and/or costs as they claim justice does not demand that security be granted and the losing party should be entitled to avail itself of due process and any and all protections afforded to a judgment debtor. Counsel for Wiseau Films conceded on this motion that the grounds of the appeal set out in the notice of appeal are frivolous as they are entirely conclusory. He stated, however, that they are not vexatious as there is no stated intention to refuse to pay any amounts deemed owing, nor is there any evidence Wiseau Films cannot satisfy a judgment or cost award. Lastly, Wiseau Films submits that to enable Roomful of Spoons to obtain information about its assets would constitute execution before final judgment. Such an order for security for judgment has never been granted in Ontario, which suggests that it is not an appropriate thing to do, so absent exceptional circumstances which are not present in this case. Analysis 1. The first issue, security for trial judgment. Section 134 sub 2 of the Courts of Justice Act provides that, on motion, a court to which a motion for leave to appeal is made or to which an appeal is taken may make any interim order that is considered just to prevent prejudice to a party pending the appeal. Rule 1.05 of the Rules of Civil Procedure provides that, quote, when making an order under these rules, the court may impose such terms and give such directions as are just, end quote. Security for judgment is an extraordinary remedy that should only be granted in exceptional circumstances. Such an order requires an appellant to post security for judgment before continuing with the appeal. In this way, security for judgment functions much like a Morava injunction and restrains the appellant from disposing or dissipating assets in order that they are to be available to satisfy the judgment should it be upheld, and if security for judgment is ordered and not posted, the appeal is dismissed. Security for judgment has been granted in other jurisdictions in the following circumstances. 1. Where there are no assets in the jurisdiction against which to enforce a judgment and the appeal has little merit. 2. To preserve assets that would otherwise be destroyed, disposed of, or dissipated prior to the resolution of the dispute. And 3. To encourage respect for the judicial process and avoid abuse of process. In First Majestic Silver Corp et al. And Davila, the court invoked Section 10 sub 2 sub b of the British Columbia Court of Appeal Act, a provision with similar wording to that in Section 134 of the Courts of Justice Act, which provides that, quote, in an appeal or other matter before the court, a justice may, b, make an interim order to prevent prejudice to any person, end quote. The court ordered that appellants who resided out of the jurisdiction without assets in the jurisdiction post security for the trial judgment, failing which the respondents were granted leave to apply to have the appeal dismissed as abandoned. In doing so, the court set out the principles governing the exercise of discretion in ordering security for a trial judgment. 1. The onus is on the applicant to show that it is in the interest of justice to order posting for security of a trial judgment and or of trial costs. 2. The applicant must show prejudice if the order is not made. 3. In determining the interests of justice, the Chamber's judge should consider the merits of the appeal and the effect of such an order on the ability of the appellant to continue the appeal. The interests of justice may be a consideration of the ex juris residence of an appellant and therefore the effective immunity of an appellant from enforcement of the judgment. They may also include a consideration of the ability to enforce the judgment in the appellant's ex juris jurisdiction and or the absence of assets in the jurisdiction in which the judgment was rendered. The interests of justice may not be relied upon by a successful plaintiff where the effect of requiring the posting of security for a trial judgment would be to preclude a party from pursuing the appeal. However, in Creative Salmon, Justice Lowry held at paragraph 12 that adverse financial circumstances will generally not defeat an application for security where an appeal is virtually without any merit. A successful plaintiff should not be required to respond an unmeritorious appeal where there is no real prospect of recovery. A finding that an appeal has no reasonable prospect of success may be a factor. For the reasons set out below, I find that this is one of those rare and exceptional circumstances where an order for security for judgment is warranted. First, Wiseau Films is out of the jurisdiction. Wiseau Films refused to advise if it had any assets in the jurisdiction, and only reasonable inference therefore is that there is no evidence that Wiseau Films have any assets in the jurisdiction. Moreover, Wiseau Films concedes that there is no issue that paying security for judgment and/or costs would prevent Wiseau Films from pursuing its appeal. As such, the interest of justice onus is met. Second, there is evidence that Roomful of Spoons will suffer prejudice if the order is not granted. 1. On several occasions, both the case management and trial judges have noted that there was numerous tactical attempts by Wiseau to delay and obstruct the release of Roomful of Spoons. Those actions are set out at paragraph 10 above. 2. Roomful of Spoons spent years producing their documentary film, and it has now been over 4 years since the completion of the film, during which there has been a cloud on titles such that they have been prevented from airing the documentary. 3. A significant judgment award may never be recovered if the order is not granted. Although Wiseau decided to commence legal proceedings in Ontario and is therefore required to abide by the rules of the Ontario courts, Wiseau Films has demonstrated no intention to pay an award ordered by this court. Mr. Wiseau said that it was laughable to ask if the sizable Pico property, which was the only known address for Mr. Wiseau, was still his address, and suggests that if his appeal is not successful, Roomful of Spoons should commence proceedings in the United States to recover the judgment. It is also telling that, although Wiseau Films did pay the costs ordered against him for bringing an improper ex parte order, he did so only after the court ordered that if he failed to pay the award, his action would be dismissed. Third, it is agreed that, as presently drafted, the amended notice of appeal is frivolous and does not articulate what errors were made in the comprehensive reasons provided by the trial judge. I am therefore satisfied that although this is a remedy that should be invoked sparingly, the interests of justice weigh in favor of granting the order for security for judgment. Accordingly, the appellants are ordered to post security for the trial judgment within 90 days of this order, with liberty to apply for further directions on the form of the security if necessary. If the appellants fail to comply with this order, Roomful of Spoons are granted leave to apply for an order dismissing the appeal as abandoned. 2. The second issue, security for costs. This court may order security for costs pursuant to Rule 56.01 of the Rules of Civil Procedure where a. The plaintiff or applicant is ordinarily a resident outside Ontario. C. The defendant or respondent has an order against the plaintiff or applicant for costs in the same or another proceeding that would remain unpaid in whole or in part. D. The plaintiff or applicant is a corporation or a nominal plaintiff or applicant, and there is good reason to believe that the plaintiff or applicant has insufficient assets in Ontario to pay the costs of the defendant or respondent, or E. There is good reason to believe that the action or application is frivolous and vexatious, and that the plaintiff or applicant has insufficient assets in Ontario to pay the costs of the defendant or respondent. As noted above, Wiseau Films parties are ordinarily residents outside of Ontario, and there is good reason to believe Wiseau Films has insufficient assets in Ontario to satisfy the awards. Wiseau Films has refused to adduce evidence of any assets in Ontario or any evidence that, having elected to proceed in Ontario, it would pay any amounts ordered by Ontario courts unless and until ordered by a United States court. Moreover, there is evidence that the proceeding is vexatious given the circumstances surrounding the ex parte order, the conduct prior to trial set out above, and Wiseau Films' concession that the appeal is frivolous. Taken together, there are ample grounds to support an order for security for costs of the trial and appeal pursuant to Section 56 of the Rules of Civil Procedure. Given the above and extension of the delay for the release of the documentary, Wiseau Films should post funds into the court. This court has the jurisdiction to do so pursuant to Section 134 Sub 2 of the Courts of Justice Act and Rule 1.05 of the Rules of Civil Procedure. Conclusion. For the above reasons, the motion is granted. In accordance with the agreement between the parties, costs are awarded to the moving parties Roomful of Spoons in the amount of $3,500.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.